you pick a jury in a divorce case? Mostly no. Do you pick a jury in a guardianship case? No. Do you pick a jury in a family court custody case? No. Family court and guardianship in Supreme Court, guardianship and family court as well, you don't pick a jury. There is no jury in family court at all. It's a bench trial. The judge presides over the case. There's witnesses and evidence, attorneys on both sides, typically cross-examination, direct examination, all of the hallmarks of our trial system. Supreme Court guardianship, it's a hearing, and that's in front of the trier of fact, the judge. It's a bench trial. And divorce, I said mostly it's bench trials. The judge presides over all issues related to the divorce. Custody, visitation, child support, equitable distribution, parenting time, fault, blame. Well, fault and blame are called grounds in divorce. Grounds. What are the grounds for divorce? There is a provision in the law, the domestic relations law, that you can ask for a jury for grounds. I've only done it one time in my career where I asked for a jury on grounds. I had a 55-year marriage and my client did not want to get divorced. I'll tell that story another time. A few years ago, the law on grounds was changed in New York. Other states have the grounds called, or the reason for the divorce called irreconcilable differences. You'll see that with your celebrity cases in California, right? This famous starlet and that famous actor, or actor and actor filed for irreconcilable differences. Just don't get along. Well, New York did not have that. We were an at-fault state. I mean, we still are an at-fault state. One side has to blame the other side. It's a plaintiff against a defendant, but the grounds that we used to have still exist. Adultery, cruel and inhuman treatment, living separate and apart pursuant to a separation agreement. These were, tough grounds. A few years ago, New York came up with the concept. They followed all the other states at the time. I think we were 49 or 50 of all of the states to pick this. Prior to that, our only uncontested divorce grounds was getting separated first, living under the rules of the separation agreement for more than a year, then you could file divorce. That was the way we could have done it. But in a contested divorce, there were no grounds that were similar to irreconcilable differences. And a couple of years ago, they came up with the grounds irretrievable breakdown of the marriage. So you can't even fight that. If I assert in my marriage that there is an irretrievable breakdown, the other side can't say, no, we really are together and we really can get along and there is no breakdown. I made irretrievable breakdown of the marriage just by saying there was an irretrievable breakdown in the marriage. That's loop-de-loop thinking.
A durable power of attorney, a useful document, an important document. The person that makes the power of attorney is the principal. I may make it for someone's right, so I'd be the attorney. But in this scenario, the principal is the person that would like to give someone else the ability to work on my behalf. So I can give my wife, I can make a power of attorney, and I can make my wife request it from her, ask her if she would like to be my agent. I'd be the principal, she'd be the agent, and she could do things for me. However, what could she do? She can go to DMV for me. She can go to the bank for me. She could deal with Time Warner Cable, Spectrum Cable, Cablevision, any cable TV company, Geico Insurance, State Farm Insurance, right? Any of the insurance companies, the IRS, deal with issues related to the property that we own, or a bunch of things. Now, her having a power of attorney does not prevent me from being able to go into my account. I can go into my account, I can go to DMV, I can go to the insurance company, I can go to the property courting agencies, I can go wherever. Her having the power of attorney does not limit me. And that becomes an issue sometimes when you're dealing with a person with the onset of dementia or Alzheimer's, where they may be going into their own account to their own detriment, spending the money, squandering it inappropriately, giving it to someone that was preying on them. So that is something to be mindful of. Power of attorney does not limit the person that granted the power of attorney. Thank you. If you need any assist, FrankBrunoLaw.com.